Good morning. Are you Randolph Fines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fines, in cause number 25 DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the
Thank you,
bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Mr. Davis, did you get someone hired?
No, ma'am. I talked to some attorneys, but I can't afford an attorney. I wrote a letter.
Who'd you talk to?
I talked to, actually, Rifles. She put it anyway. Mr. Wilkerson, law firm, I talked to Justin Gilmore.
Okay. Are you working?
The job is not started yet, but the habitat, it's coming up, but it hasn't come through. Building too many houses.
All right.
I have
So I don't need to read your letter. I just need, since you did what I asked you to, I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. Don't just leave it all blank and put zeros. Put any bills you have, any income you might have, and then I'll take a look at it. If you step in front of the clerk over there, she'll give you that paperwork. Good morning. Are you Lacaria Kirkwood? And Ms. Kirkwood, this is your initial appearance in cause number 25 DCCR 0190. You're charged with the state jail felony offense of unauthorized use of a vehicle from January 8th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Ms. Kirkwood, is reset your case about 30 days to give you some time to try to hire somebody. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those that you've talked to and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice.
Just before we begin, I'll let you know what we've proposed to see.
Okay.
If you even go any further or not.
Okay.
We were here a couple weeks ago on Mr. Byerly. It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today. I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had semi-made the suggestion of ISF/SafeP. It came to my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all 3 of the felony cases for a revocation, which would then make him a repeat offender if he's back in front of you.
Okay. And that's your understanding and your agreement as well, Mr. Burbank?
Yes, Your Honor, and we prepared paperwork and 3 indicated 2 MTRPs and new possession.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't see the new case.
Possession that I sent.
So, we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea.
3, 4, and 6, Your Honor.
Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And we can print the ones that were already modified. That way I can make notations on that.
And Judge, just again, I know I had let you know last time, I'm not meaning to interrupt you.
Go ahead, I'm
while you're
just
reading.
praying.
Obviously, the concern of the original underlying offenses back in 2017 that carried on until 19 was the violation of protective order. I've continued to maintain contact with that family and can assure the court that they have assured me that there has been no issue with Mr. Byerly.
Good.
So
Thank you for that as
I
well.
just want the record to reflect that.
Okay. Okay, I'm getting there. Okay, so,
Would it be better if I made an oral motion to withdraw previous?
nope, I'm just going to go back and I'm going to just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
Be well in
The motions.
all cases.
Okay. Mr. Byerly, in cause number 18-28800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Correct.
And then in cause number 18-29063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a 3rd-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go,
1, 2, 3, 4, and 6.
okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5. 6 is that he possessed it. I mean, but 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one.
Oh,
One is 6 and
great.
one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count 1. in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
2. And then count 3 alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count 4 in each case alleges that you failed to abstain from the use of any and all intoxicating substances and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count 5 in cause number 18-29063 and count 6 in cause number 18-28800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
I understand.
State tenders number 1 in each of those cases. It's admitted in each of those cases. Is there any evidence that Mr. Byerly is not competent? All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 18-29063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 18-28800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you. Give me just a second now. Those 2. And did I print 2?
Yes, ma'am.
Okay. Now let's go to okay. Now, Mr. Byerly, in cause number 25, DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number 1 in that case. It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that. Okay. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or corrections?
And from the defense.
Not for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork.
Okay.
Good luck to you, sir. Thank you.
Thank you.
Good morning. Are you Kevin Ross?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the motion in each case?
Well,
Mr. Ross, in cause number 24, DCCR 1198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a deferred probation for 4 years. Is that correct?
Yes, ma'am.
It alleges that you, and then I also have cause number 24, DCCR 1199, also a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 18th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was also a 4-year deferred probation. Is that correct?
Yes, ma'am.
Tell me again why we're doing this.
Judge, DPS did bring the video in. They have yet to submit the case formally to be indicted on the evading. So our thought was to allow that to come in, maybe hold it, see how he participates in ISF. Certainly, if based on the circumstances we need to rediscuss it, we can. I don't believe he's had any write-ups while he's been in. I mean, obviously, the new offense was quite
Yeah,
egregious.
Well, and that's if you're on probation for that and then you do it again, six months after you were placed on probation?
No, I would only ask to let him go. That charge is still out there. And then we can address it depending on what the court wants to do, or we come in front of the court again.
But if he pleads on it now, then I don't think even if it's indicted, I mean, if he pleads true today
Right.
to the new offense, and I do what I do on these motions and reinstate and send them to ISF, if the case is then submitted, or when it's submitted, you can't allege the same thing again and then me re-punish him for the same offense that he's already.
It's the new offense that you would address.
But y'all said that today. Count one is the new offense.
Right, but it's-
I can't do it twice.
It's a new warrant.
Well, once it comes back, once it gets indicted, then it can be addressed.
On its own abstinence.
Yeah, on that, not the NTRP, but the new offense.
Well, I know, but then we have two probations and a new offense, and the argument then is going to be, we'll leave him on probation because you can't revoke him because you already did this. Because I already took it into
But you also
consideration
have
on
the
these
option
motions.
of leaving him on probation and then sending him to the penitentiary if he doesn't do well on the new offense. See what I'm saying?
I know, but that's just, I mean,
Would you
Any
prefer,
word
Judge,
on
that I
where
just-
that is and
that I
why
just
they're-
reach out to them again? I know last time it was kind of in the context of that conversation.
Yeah.
If you don't want me to call them, you're gonna call them.
Yeah.
I can do that, and I can get it to grand jury by next Wednesday.
I just would like more information, I think, before, on that case. I don't
Right.
think we need to have them on a probation, and then those out there pending, and then in the middle of ISF, they send it. If a warrant's issued, they're gonna kick them out of ISF anyway.
They were gonna hold it until he got out, Judge.
I'm gonna reset it just a short time. If you will reach out, or if I need to reach out, I understand, I appreciate that they, I guess, cooperated somewhat with getting the video, but I think I'm gonna look into that a little more myself and find out where it is in the process and why it has not been
Yes, ma'am, because
submitted.
the offense date was June 13th.
Yeah, that it makes no sense to me. And from what I recall, it was not just a couple of blocks going slow. It was, okay,
I'll have investigator Bates reach out this morning, and we'll get it indicted by next week. If maybe an update would be beneficial.
that's what I'm thinking. I think I'm not gonna just automatically do it. I think if there's gonna be pleas, we can do an updated PSI. I wanna know more about everything that's been going on before I agree to something like this. All right, you can go back with the bailiff. Would you? Good morning, sir. Are you Michael Barelick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And it's just the lesser Class A theft, correct?
Yes.
Mr. Barelick, in clause number 25, DCCR 0003, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Barelick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor theft of property. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you, thank you, Clerk.
And sir, you Juan Martinez?
Yes, ma'am.
And Mr. Martinez is charged with assault of a peace officer from March 23rd of 2025. And what is the announcement?
Judge, on this one, we would ask for a reset. Spoke to Mr. Peraza this morning, and I want to go back and look at the body cam video.
Okay.
before we proceed.
Okay, so I'll do just a normal reset, which is about 30 days. And that'll give Mr. Smith to go through that, get back with you. And Mr. Martinez, make sure you stay in touch with Mr. Peraza, so you guys can go over everything that he receives and know what your options are when we come back. Okay?
Okay.
Yes, Judge.
All right, thank you. You're free to go. I'll send you a lot. Thanks a lot. Appreciate it. Good morning. Are you Kevin Calise? And Mr. Calise, this is your initial appearance in cause number 24, DCCR 1948. You're charged with theft of property from July 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Did you get someone hired already?
I've talked to somebody, but I'm willing to get somebody hired.
So what I'll do is reset your case about 30 days to give you some time to try to hire somebody. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Thank you for getting here, Ms. Ollie. I'll recall that bond forfeiture. Thank you for calling and letting us know you were having issues. That's all it takes to not be in trouble. So this is cause number 25, DCCR 0532. Were you able to get a lawyer hired?
I reached out to Lone Star. I paid their consultation. I'm waiting on a call to see if an attorney will accept my case. I reached out also to James R. Macon, a criminal attorney, for their consultation and to get a full fee for the service. And then I reached out to Dewham and Jones Law Firm in Houston with their consultation, and then to get a full fee for their services will to take my case.
Okay. Thank you for doing what I asked you to. Are you able to afford any of that you know of right now?
Just the consultation.
Just the consultation. So I'm going to have you fill out some paperwork, Ms. Ollie, this morning to see if you qualify for a court-appointed lawyer, since you've done what I asked you to, okay? You need to make sure and fill it out accurately and completely. Don't just leave it all blank. Put any income you might have, any bills you pay. You're going to swear under oath that it's all true and correct, and then I'll take a look at it, okay?
Yes.
If you step in front of the clerk right here, she'll give you that paperwork. Good morning. Are you Stephen Wilburn?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Wilburn, in cause number 24, DCCR 2346, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that is from September 27th of 2024. The indictment alleges you were previously convicted of driving while intoxicated November 24th of 1998, June 29th of 1999, and then again April 26th of 2000. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison that would be probated for 6 years. You would have a $1,000 fine and be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Any evidence Mr. Wilburn is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there. All right? We'll see you back at sentencing.
Thank you, Judge.
Alan, did I get discovery on that one? Good morning, ma'am. You're Crystal Latulis. And Ms. Latulis, this is your initial appearance in cause numbers 25 DCCR 0850 and 0851. In each of those cases, you are charged, sorry, give me a second, with the second-degree felony offense of abandoning or endangering a child, and that's from May 30th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
This is the thing, Judge, I'm gonna be honest with you. My child or whatever, when I got out, I had no stipulation.
Speak up, please.
When I got out, I had no stipulation, right? So the week that I got out, I got a call from that she said that the child had to be removed from the home. I'm a parent at the end of the day. I have a nursing license that's interfering with this charge that I have now. That was my whole point of starting over. I already had got my nursing license, but I'm going.
Okay, you're telling me way too much information.
Okay.
Here's the thing.
I was just asking about my child. Is there any type of way that I could get?
You need to get a lawyer, and they can file a motion asking, but just with your word, based on what you're charged with, no, I'm not going to allow that at this point, okay? So I'm going to expect you to try to hire a lawyer, reset your case about 30 days to give you some time to do that. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Okay.
Do you understand?
I don't. He told me something about the version you just stepped out.
Okay, that's why you need to go hire a lawyer, okay?
Yes, ma'am.
Step in front of the clerk. Good morning, you're Daryl Spencer. And so, Mr. Spencer, you've been here previously in cause numbers 24 DCCR 1863 and 24 DCCR 0841. And then it looks like there were 2 new indictments that have come down, and so you now have an initial appearance in those cases. One of them is 25 DCCR 1149, and in that case, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 14th of 2025. And then the next one is cause number 25 DCCR 1150. Hold on a second. And in that case, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from June 15th of 2025. And so since you've made bond in these cases, have you had an opportunity to try to hire a lawyer?
Yes, ma'am, I had Raquel, he told me he was supposed to be with me today, I texted him last night. He told me he was gonna send a letter to the representative, but I paid him when I came here that Monday. I came and talked to you.
Have a seat in the courtroom. Don't leave until we talk to him, okay?
Yes, ma'am.
All right, go ahead. You can have a seat.